All right, I'm going to give a couple of seconds to let attendees start filing in before we kick things off officially. Okay. Good afternoon, everyone, and thank you for joining today's Wednesday Wise webinar. My name is Sydney Konahia with the International Franchise Association, and we have a great 60 minutes lined up for you all today. Before we kick things off, I just wanted to touch on a couple things. Today's webinar will be recorded, and a link to the recording will be emailed out to all registrants after the webinar. And if you have any questions for today's speakers, please feel free to add them to the chat or questions box, and they will address them towards the end of the session. Today's topic is the Compliance Balancing Act, the franchisor's perspective on supporting franchisees without triggering joint employer liability, and is brought to us by Polsinelli. Here to provide today's discussion are Angela Spinola, shareholder at Polsinelli, Sheila Davis, Chief Operating Officer of Always Best Care, and Nikki Holes, Senior Vice President, People Strategy and Governance with Right at Home. Thank you all for joining us today, and thank you again to Polsinelli for sponsoring today's Wednesday Wise webinar. I will now turn things over to you guys to get us started.
Thank you. One quick thing, there are no holes in Nikki's game. She is Nikki Hollis. No holes in this game. Welcome, everyone. Thank you for attending. This is an age-old issue for franchise systems and the franchisor of what can we do and how do we support our franchisees in the way that they expect us to without running afoul of joint employment and other vicarious liability type of issues. So there's nobody better to join us in having that discussion than Nikki and Sheila. We will get to a panel discussion with them. We're also going to introduce a really cool software program called Posse. And Nikki and Sheila are, their organizations are subscribers to a sister business that's called Posh. We'll talk about all of that and how that resource can be used to assist with joint employment liability. And that's one of the primary reasons that we built it here at Polsinelli. If you're not familiar with our firm, we are a I think AmLaw 59 now, large firm. We cover all of the United States. We have more than 25 offices. I don't know what that means, by the way, 25 plus. I think it's just that the marketing people just get tired of updating how many offices we have, but we got a lot of offices. We work with a lot of you already. We have a great franchise team, and we're really full service. And this is a real passion of mine to help and provide resources to some of the smaller businesses that aren't normally able to work with firms like ours through subscription services and things like Posh and Posse that we'll be discussing today. I am the co-chair of the Home Health, Home Care, and Hospice Practice Group. I am an employment lawyer. I sit in Atlanta. Sheila Davis is the COO of Always Best Care, and Nikki Hollis, aka Holes, is the Senior Vice President, People Strategy and Governance at Right at Home, who sits in Omaha. So without any further ado, and I was saying this to Nikki before we started, I always overpack these things because there's so much I want to say to you in such a short amount of time. So I'm going to try to go fast and start with an update on what's going on as a result of the Trump administration and parlay that into the joint employment discussion and how things have moved from federal to state law. We'll talk about the number one killer of joint employment litigation, which is arbitration programs, have our panel discussions, and then introduce you to Posse, our newest offering. So let's start with the Trump administration and what we've seen. One, there was a real effort to reduce regulation at a federal level, and I think we are seeing that. Maybe not in all the ways that we anticipated that we would see it, but we are seeing a change in federal oversight in a lot of ways, at the NLRB, at the Department of Labor, at the EEOC, a repeal of guidance and some of the regulation that we were seeing from those entities, elimination of liquidated damages, for example, during DOL investigations. There's the return of the paid program, which allows for self-disclosures to the Department of Labor to resolve things, short of an investigation. So there is a lot of that happening. And what we are seeing now, and this has really been a trend over the last several years, it's just accelerated now much faster, is that states and even cities or counties are creating law at an unprecedented pace, and not waiting for Congress or lobbying the feds to do things, particularly given all the back and forth, right? Depending on who's in office, the states are and cities are initiating their own legislative changes, and it's happening very rapidly. And more or less, particularly national businesses or franchise systems, right, that are across multiple states, are having a very, very difficult time keeping up with those changes. So the bulk of my discussion is going to be around that. But what have we seen? OSHA, we've seen some relaxation of some of the OSHA standards, like the proposed heat safety rule that would regulate what the temperature of a work place could be. Some abandonment of the FTC non-compete. There was an attempt to ban non-competes in totality with employees other than for highly paid executives. The FTC is still very focused on the non-compete issue, and they are still enforcing it, but they're doing it based on a reasonableness standard. How are you using non-compete agreements? What employees are subject to non-compete agreements. They're looking for the kind of businesses that would have every single employee sign a non-compete or use alternative agreements to prevent somebody from actually working in other places rather than protecting the business. So it's not going away, that the enforcement of non-compete, and largely that's been a state issue anyway, but the FTC is not going to have a prophylactic ban on all non-competes. This one is related to healthcare with the 80/20 rule and fair access to Medicaid rule. We expect that's going to go away. That was where the government was going to cap the profit that a Medicaid business Medicaid provider could receive, where 80 cents on the dollar would have to be paid to the direct care worker. Salary level increases were underway under the Biden administration, where the salary levels for exempt employees were going to go sky high. And that had already started. The salary level had gone up to 47. It was going to go up again. And that has now been abandoned. So we're not going to see those salary level increases. We might see something, but it won't be at the level that it appeared like we were headed under Biden. This matters to Nikki and Sheila. The domestic worker exemptions are likely coming back. That's probably something we're going to see next year. The comment period just ended on that. The Corporate Transparency Act, which was the beneficial owner acknowledgement, where you had to report if you had were an owner of a business that made less than 5 million in revenue annually, and provide your contact information and ID and those type of things if you own 25% or more of your business. That has gone away. That was another sort of federal oversight type law, the likes of which we really hadn't seen in the past. Which will apply, this will apply to everyone here. The joint employment standard, the NLRB's proposed changes have been defeated. We have returned to the 2020 joint employment standard. That is for union organizing and unfair labor practices, right? That relates to the National Labor Relations Board. So remember, there are lots of different joint employment standards. The Department of Labor is also looking at modifying their joint employment standard to make it more difficult for someone to argue that the secondary employer or the non-statutory employer, right? You have your statutory employer that everybody recognizes, and then a individual owner or a franchisor or a sister company or a parent company could also, or a staffing company, be deemed a joint employer and have liability under that standard. Those standards at a federal level appear to be softening. The IFA is doing a really good job of shepherding some legislation that will codify, hopefully this will happen, codify the 2020 joint employment standard, which is basically direct and immediate control is what it would take to establish joint liability under that standard. So that's great news, and we hope that comes to pass. But I do want to make sure everyone understands I am an employment litigator. I litigate class action cases and joint employment cases all of the time. And what I want everyone to understand is and I'm going to actually show you an illustration of this in a little bit. The joint employment argument is used to increase the value of a case for settlement purposes. That's what plaintiffs' lawyers use joint employment for, not to actually win on joint employment. Very rarely do you see a joint employment case go to trial. It happens, but most of the time, the idea is just to survive a claim so that the joint employment claim can wrap in or bring in other potential deep pockets, right, and liability risk for the franchisor or the owner, right, to increase the value of settlement. So the number of cases filed alleging joint employment are not going down, and I doubt are going to go down as a result of the standards getting better. Our ability to defend those cases is getting better, and that's great news. We may also see some changes to the federal standard for independent contractors. That's a possibility. There's been some discussion about that. A lot of what the NLRB was doing around what you need to have in your handbook and the types of policies you can have and non-disparagement and those type of things, a lot of the chilling policy communications and guidance from the NLRB have been repealed. The opportunity for AI tools, the path has been paved, whereas the Biden administration was really looking towards a European style model with a lot of oversight and regulation. What Trump's position is more of self-regulation and using industry experts to identify what AI regulations and requirements should look like. That is an area where more than any, we're seeing the states are driving how and when and what notices are required to use AI. So I think there are 22 jurisdictions that already have some law around the regulation of artificial intelligence and another 22 that are in the process of enacting such legislation. So something to pay attention to. And as I mentioned, what we really see now are the states issuing rules, regulations, laws pretty rapidly and not always well documented, particularly if they're industry specific kind of laws. And those laws are often strict liability. And what that means is that if you have violated the law, regardless of whether you knew about the law or intended to violate the law, that's not relevant, right? What's relevant is, did you do it or did you not do it? And so I'm going to look with you at several examples of this because I think it's just so important for employers to recognize and understanding what these things are so that you don't get caught in that trap. You have plaintiffs' lawyers who wait for the law to change and then they start bringing lawsuits because you either didn't provide the form, you didn't ask the question, you asked the wrong question, whatever it is. And there's a way to identify which states and which kind of activity is riskier than others. So for example, something like a salary history inquiry, if that's on your application and you're in a state that doesn't allow you to ask about salary history before somebody is hired or maybe at all, then the mere fact that this exists on your employment application will give rise to a potential claim. So if a plaintiff's lawyer can get a hold of your employment application, you may see a class action around salary history inquiry. So what we're showing you with this map, and you're going to see several like this, are states, the light blue are the states that have salary history, some sort of salary history law. The ugly mustard color is when it's regional. So it might be a county or a city. And then the pink is when you have both like New York and New York City, state and um, municipality law. So this one is similar. Think about an application, and does the application ask about prior criminal history? Instead of salary history, ban the box is generally referring to criminal history. And if there is a part of your interview process or questions about that, when do you run background checks, right? That's relevant, particularly in the states that are blue, pink, or mustard. I refuse to call that yellow. So just look for your state, and the goal here is to just show you how different the states are and how many. This is just a handful of the kind of things that we see. I had mentioned earlier that generally non-compete law is driven at a state level. You look at states and cities to determine whether there is a non-compete or non-solicitation. Those are two different types of agreements. One prevents you from working for a competitor. The non-solicitation agreement prevents you from hiring away generally the customers of the business you worked for, or the clients, right? Clients, customers, or other employees that you worked with. So you can see, highly regulated at a state level. There are lots and lots of minimum wages, both at a state and city level. I think that businesses are generally pretty good at keeping up with their minimum wages. You don't see that many minimum wage violations, often also because of market conditions that don't allow you to pay minimum wage, certainly not state minimum wage or federal minimum wage at $7.25 an hour. Where you see companies run into problems is often in places like California, where you could move from San Francisco to San Jose if you have a traveling worker, and all of a sudden the minimum wage has changed based on where that employee is working. Some states also have unique independent overtime laws, so we have to pay attention to that. That really matters in connection with the companionship and live-in exemption changes that we were talking about earlier, the domestic worker exemptions coming back. There are some unique exemption requirements that are really important, both for job descriptions and job duties. So you may have somebody that's exempt under federal law, but they're not exempt in California because they perform exempt and non-exempt work at the same time. So really important that you understand what the exemption requirements are in each state. Some states have different exemptions, entirely different exemptions to overtime than federal law would. States also have unique laws around when training time has to be paid. So there's a federal standard for when you have to pay for training time. One of the biggest challenges with that standard is if the training is job related, if the person is, even if it's voluntary training, if it's related to the job. So think about your lunch and learns. If you're providing lunch and learns to help somebody do their job better, that's got to be paid time because the training is required to be paid under federal law. But states also have, as you can see with all the light blue states, independent requirements on when training time is compensable. One thing I should have mentioned early on is, what do you do when there's a distinction between federal and state law? The way this generally works is, if federal law is covering the issue and it's inconsistent with state law, it's covering the same issue. So federal law says one thing, state law says another thing. The federal law will often supersede the state law, right? An example of that would be California a few years back tried to ban arbitration agreements, which the Federal Arbitration Agreement or Federal Arbitration Act allows. And the California law was preempted by the FAA, and the Supreme Court of the United States came down and said that. New York has tried to do the same thing. So sometimes you see that. But if the state law is more favorable, it's on the same issue, but more favorable, then you follow the state law or whatever law is more favorable. An example would be the California, both state and city minimum wages are much higher than the federal minimum wage. So you would have to pay that higher minimum wage or you'd be in violation of California law. In Georgia, the state minimum wage is actually lower. It's $5 and 5.45 or something insane. Um, so you could, pay that amount of money, but you'd be in violation of the federal minimum wage of $7.25 and subject to a claim under federal law. So whatever law is more favorable to the employee is the one that you must follow. Okay, now that we've covered that, let's jump back in here. This is one that really, ties companies up a lot. Business expense reimbursements, and this is generally governed by, so California, my California people probably know that they have a requirement to pay for mileage when it's compensable travel time, that there's a requirement to pay for a portion of somebody's cell phone if they're using their cell phone for work purposes, right? That's part of the business expense reimbursement requirement. But I bet you that my people in Illinois do not know that a very, very similar law is on the books for them. And that's a product of the lawyers bringing bunches of lawsuits in California, but not yet in Illinois. It's coming. We're going to see that, right? Because that's the perfect gotcha claim of, oh, here's an industry where they're using cell phones and they're not providing any reimbursement for cell phones. I'm going to sue this one company, right? Let's call it just a sales company, right? And I'm going to now, now I've got my case set up and I'm talking. This is not me talking, it's the enemy, right? Who I defend against, but this is the way that the plaintiff's lawyer thinks, right? Now, I've got the precedent and got the case. Now I will sweep the industry and just go after everybody because they all do it the same way. And one of the biggest defenses that we always hear from our clients is, well, that's how, so and so does it. And they'll identify some large company and say, well, that company isn't doing that. So why do we need to do it? And that's why all companies in the same industry get sued. It happens right away. So there's nothing going on, nothing going on. Everyone thinks it's okay. And then all of a sudden you see this sweep of lawsuits, and the statute of limitations on these things is normally years, 2 years, 3 years, 4 years, in New York, 6 years. So just fixing the problem, saying, oh, well, now Walmart's gotten sued for not, paying a, reimbursement for cell phones. Now we better do it. Well, that's great going forward, but what do you do about the last 4 years or 3 years? So that's generally the issue. So, I'm pausing here to make sure you're taking a look at your state. Not every single state requires cell phone reimbursement. That's not what I'm saying. I'm saying that the states in light blue, um, and I don't think we have one where it's local only that I can see here. Um, you need to pay attention to those states because there is some requirement. You need to make sure you know what it is and you're complying with it and you have the right policies in place. Meal and rest breaks. This is another one. This may be, it's hard to say what the top litigation is, but meal and rest breaks are right up there when it comes to pay practice litigation at the very top. I've always said, like, if you're in a state like Texas that does not require you to provide unpaid meal breaks, that maybe you shouldn't do it, especially if you're in an industry where it's difficult to monitor and make sure that folks are actually taking 30 minutes, just, give them paid breaks. But in some states, you don't have that option and you have to provide unpaid meal breaks. In states like Washington, you have to ensure they actually take the meal break, or you're liable, and you're not just liable for missing the meal break, but also a penalty associated with it. One of the wildest ones I've always thought is California, where if you miss a 10-minute uh, paid rest break, a 10-minute paid rest break, you're paying them an hour, right, of additional time, which is wild. So the penalties in these cases can stack up to be much, much higher than whatever the back wage liability is. Live in, sleep time, and meal time. This is a little more nuanced for home care, but there are a lot of independent laws in these states around those issues, and ever growing with the Domestic Worker Bill of Rights continuing to pass. This is a good example of how state law steps in where federal law doesn't complete the job. So the feds, it was actually Kamala Harris sponsored this bill, was looking for a federal domestic worker bill of rights, and it never made it through Congress. So now you have domestic worker bill of rights in Seattle and in Washington and in Philadelphia, excuse me, just Seattle, in New York City and in New York, in Cook County in Illinois. New Jersey was a recent ad. We've got some that are proposed. So lot of changes. You know, you all are probably familiar with the paid sick leave because that generally gets covered well. And then oftentimes the idea for another law like this arises from California or New York. It used to be California exclusively. So paid sick leave was one of the first. And so you can see how prominent it is around the country now to have paid sick leave laws. And then other states just start to follow suit. This is a major one that we're seeing a rapid increase in is workplace violence, and laws and plan requirements. So make sure that you understand what the requirements are here. This one's a really fun color-coded one. I was trying to even understand, so I think like California, there's a plan requirement and there are employer rights. So the idea of employer right and that mustard color, meaning that if there is an issue or a concern around workplace violence, the employee will have some special unique rights, like gun safety, for example. If somebody whose home you're coming into has a loose gun, in a state like that, you might have the ability to require them to secure the weapon. And then a couple more here, and then we'll get to our panel discussion. The employer-sponsored meetings has been a hot one that we've seen coming up. You see Illinois and California just issued their laws, and this is simply that for meetings that are employer-sponsored that may revolve around a political topic or a religious topic, that employees have the right to opt out of those meetings. You're probably doing that already without any fear of retaliation. This one I want to take a second on the wage transparency laws, because this is one that we have seen a lot of litigation around. And this is, I think, the perfect example of what I refer to as these gotcha claims. So wage transparency is simply the concept that on a job listing or a posting, or when you're communicating about a position that's available, you have to tell the applicant what the salary range is or the hourly pay range for that position. It's very similar to the ban on salary history, right? The idea is if you have women and men in the same job being paid differently, we want to provide disclosure to the applicant of what the high end is and the low end, so they can decide if the offer is fair or not, instead of keeping things in a vacuum. So it's well intentioned, but it's been abused, right? So this in the state of Washington. So if you're in Washington, hear what I'm saying now. Has had so much litigation around this, because what has happened is the plaintiffs' lawyers have been trolling Indeed, Monster, the places where job postings would sit, just simply looking to see, is there that pay scale or not, right? And if the pay scale isn't on the posting, then you're in violation, up to $5,000 per violation for every job posting that you have out there. So think about large companies like Home Depot and any, Cadobo was one, right? Any big company that isn't aware of this, they're going to have millions and millions and millions of dollars in exposure, right? So that's exactly what happened. Is you had plaintiffs' lawyers, hundreds of cases now, um, that are bringing lawsuits. They'll have a plaintiff who's not qualified for a position just apply for the job that they're not even trying to get, and then bring a class action lawsuit, and then they pull that off and settle it for millions of dollars, right? That's what's going on. And the Supreme Court of Washington just came out and said there was an argument about, do they need to be qualified or not? What if the applicant isn't qualified? Could that be a defense? And the answer effective was no. So we're not going to see any shortage of these cases. So go and look at your job descriptions and job postings if you are in one of these states. Probably a good idea to do anyway, because again, that's the type of thing where um, the law keeps changing, and we're going to see more and more states adopt that wage transparency style of law. So one of the things that can help you, and I think it's so important, right, to understand, is an arbitration agreement that has a class action waiver in it. So that doesn't help in Washington, right? Because the agreement is with employees who are working with you, and Washington is able to, the plaintiffs are able to apply for a job without um, the the arbitration. One of the things that we're doing with our clients is we're actually putting arbitration language in the job application, right? So I've applied, I've got an arbitration provision in the application, not like the big one that you would typically see, for an employee that has all the details, but enough to get a class action waiver, because the reality is that nobody sues around joint employment. Nobody pursues, things that are individual cases with a $5,000 cap on a fee is very, very different to a plaintiff's lawyer than the opportunity to bring a case representing hundreds of applicants, right? Or because you had job postings everywhere. So the idea is you utilize arbitration to get out of this litigation timeline, right? And to move things along much faster and on an individual basis. So it really is one of the key components. You want to do everything you can to be compliant and to keep up with these laws, but you also want to have tools like arbitration, right, that will keep you out of this litigation process, where the lawyer knows if they've got you in this and they've got a potential class action or a joint employment claim, they know that you're going to probably settle that case, because you don't want to go through all this to try to get a motion for summary judgment or to win on at a trial when the liability could be very high, right? Or even if it's not very high and you feel really good about your defense, the expense of going through this is very high. So arbitration is a great way to cut to the chase. And why this matters so much in a joint employment setting is joint employment claims. How many of them do you know of that aren't class actions? Almost all of them are class actions, because that's the only time it makes sense to try to pull a franchisor into the litigation, right? If it's a $5,000 litigation or a $15,000 litigation, you may still be a joint employer. You may still have overstepped the line, right, of how much you can provide and what you can do. But the question is, who cares for $5,000? Was it worth my time as an attorney to try to pull you into something like that? And again, I keep saying, I speak in the first person. It gets me in so much trouble, because everybody who listens to me is like, oh, this is the guy that's suing us. He's suing us. He's saying it's not worth his time to go after us. That's not me. I'm the guy that defends you against those guys that come after you. So be aware of that. So there are decisions that you have to make about arbitration. Sometimes they need to be state specific, like in California, but they are enforceable and work everywhere. More on that later, but let's get to our panel discussion. And maybe we'll start, Nikki, with you, if you want to just explain your role and a little bit about your organization, and then Sheila, you go, and then I'll ask you my questions. We'll fire them off.
Yeah, great, Angelo. Thank you. Hi, everybody. My name is Nikki. Angelo, it's always a pleasure to do these things with you. So thank you for the invite. My role here as SVP of People Strategy and Governance really just means that in my role, I have a handful of more subject matter expert types of teams that I oversee here at the franchisor level located in Omaha. We have franchisees, over 300 unique franchisees across our network, across the United States. We have global locations as well. Of course, I stay in my wheelhouse here in the U.S. And I provide really that level of oversight for coaching. And I've seen some really great questions in the chat here, and I can't wait, Angelo. You're killing me because I just want to dive in. I want to answer these questions. But it really does. It comes down to that consultative approach as opposed to the direct approach when you're working with franchisees, and just really making sure that we're maintaining that line here at the corporate office and how we're coaching. So.
Great.
Yeah.
Sheila?
Sheila Davis, Chief Operations Officer here at Always Best Care. Similar to what Nikki explained, we are a franchisor. We have about 150 office locations across the United States and Canada. So, really, again, as Nikki iterated, it's that consultative approach of overseeing over anything operational wise, according to the franchisees, and really assisting them to provide them with materials and tools so that they can be successful and compliant within the rules and regulations of their industry.
Great. Excellent. All right, let's jump in, and I will, while you all were talking, I had a chance to look at the chat, and everybody is asking a very similar question, which is, what gets me in trouble with joint employment, and how do I, it's the tension we started with in the beginning. How, if I don't do enough for the franchisee is going to come after me, and the franchisee is going to be upset that I haven't supported them enough, and why do they buy into this brand without the support? But then you're saying if I do too much, and if I provide documents and things like that, then I'm at risk of a joint employment liability. And then there's also something else in between that I've litigated a lot. I've litigated a lot of joint employment claims, which is you do provide stuff, and it's not the plaintiff's lawyer that comes after you. The plaintiff's lawyer goes after the franchisee because the stuff is out of date, right? Maybe you updated it on your intranet as the franchisor, but the franchisee is using an old version. I had a background check case like this where the franchisee was using an old version, right, of the consent form that was replaced by the franchisor. And now the franchisee wants to come after the franchisor for saying, hey, you gave me a bad bill of goods.
Right.
So question, and let's start with you, Nikki. How do you determine the line between what's helpful support and what is over the line as far as control? What do you do as an organization, and how do you spin that?
So, I would really have to say it's probably threefold as I think through this. And so the first piece, again, I just continue to go back to that. It's consultation. It is not direct control. It is not whether it's a coach talking to a franchisee, whether it is, talking to somebody in the office levels side of things at the franchisee level. It's always here's what we've seen work well in the past, or here are some best practices that we have learned from other franchisees, or here are some things that I have heard or have witnessed be a good practice. But always reminding them that they have to, it's up to them. At the end of the day, it's up to them to make those decisions for their business and how they're executing it. I would also say the second point that I just said is a lot of times franchisees are having their office staff communicate with the franchisor, and they're saying, hey, hey, John Doe, reach out to the franchisor, to the coach, get some information from them, and go from there. And really, we always like to remember that we have to come back to who our agreement is with. Our agreement is with the franchisee. Our agreement is not with the employees of the franchisee. So the franchisee is the one that should be directing what that employee should be doing, not the franchisor. So always ensuring that we are maintaining that level of, listen, yes, we'll provide, again, knowledge, best practices, resources, but at the end of the day, the franchisee is the one making the decisions on what they're doing. And then technology, Angelo, you alluded to it, but whenever possible, I always say if there's something that an employee of the franchisee is going to sign, something that you might want to pull out in a court or in some sort of deposition that somebody acknowledged, then have it be something that is put together by a group of professionals that their job is to keep it updated. Their job is to ensure that it is compliant. That's not our jobs. That's not what we should be doing. Let's brand and make things the way that we want our brand to appear. But when it comes to, hey, kind of legal documents, let's put that in the hands of the experts and host them somewhere else. So Sheila, I guess I'm trying to talk fast because I want to make sure that you have a chance as well.
No, I would reiterate everything that you just said, Nikki, is exactly the same. I mean, it has to be from a coach and a mentorship and a consultative approach. The franchisees are their own independent owners at the end of the day, so they are the ones that have to be making the decisions, as you stated. We can't be making decisions for them. But I think that the technology aspect of it is really where we're trying to drive our franchisees as well, is that HR is an ever-changing platform. It's not what it was 5 years ago for sure. And there's so many changing rules and regulations just in the 30-minute overview that Angelo was able to give. I mean, you can see that there's so many aspects of HR today that a potential employee or someone out there in the field could potentially cause, to a franchisee. I think the arbitration agreements is something that we were able to as a best practice, encourage our franchisees to implement to try and save them against best class lawsuits. I can actually say that we've had a couple of franchisees that were able to deter class action lawsuits because they had arbitration agreements in place. So I think it is leveraging that technology. That's where I am very proud to say that we are partners with Postinelli and their online solutions, and that we have a database on a state by state given basis for them to access all personnel record requirements that are up to date. And we can confidently say, go out to, and Angelo will get to it in a minute, go out to the POSH website or the Posse website and obtain your forms and your employee handbooks and your agreements that need to be executed and kept on file, because we are in the knowledge of that those agreements are updated annually at the very least, and sometimes on a monthly basis. So, that's our place, and we continue to urge our franchisees to utilize those resources.
Yeah, that's great. And so a couple of other things that I think are useful, very helpful. One of the things that we've done, and I know we've done this with you, Sheila, actually both of you, now that I think about it, is acknowledgments with your franchisee right off the bat, right? That the franchisee understands what their responsibilities are and that it's their responsibility to be compliant, and you can provide tools and resources and you will do that, but that doesn't mean that they're comprehensive and that that's everything they need, such that they're depending on you, right? Because I think we can be sitting in the wrong seat as a franchisor. There was a question that Mary asked a little earlier. If we were to provide, and I want to use this to kind of illustrate what I was just talking about, franchisees a template for an application and an interview process we use, or descriptions of the positions that we hire for, does that create a violation in any way? And if we train their staff and they pay us, will an invoice be enough evidence? Right. So I think that utilizing, and this is really what Posh and Posse are designed for, right? Where it's resources that are licensed, right? The franchisor may pay for those resources. Sometimes it's a combination, but they're licensed to be used by a third party rather than a template that a franchisor is using, say, in a corporate-owned location, right? That now is subject to scrutiny and potential joint employment liability, right? And the issue there is, what if you provide an application and it's an application that works in Texas, but it doesn't work in California, and you may say to the franchisee, you need to get this independently updated and all that stuff, right, on the phone or something like that, or in an email. But now you're defending that, right? When the franchisee gets sued for using the application and something being wrong with the application, and either the franchisee or the lawyer comes directly to the franchisor, and that's what they love. Oh, this is a franchisor form. This came from the franchisor. Well, that now ropes in the whole system, right? So I would strongly encourage, when it comes to HR documents, there's certain things, brand standards and the like, that you absolutely can and need to provide to your franchisees. But when it comes to HR documents, that's a really risky proposition. So that leads into my next question. For you all, how are you using Posh? What features of Posh have been most useful in maintaining that legal separation? I know, Sheila, you just mentioned the arbitration being pretty helpful for the franchisees. What do you use, or what do the franchisees use Posh most for?
So we encourage them to utilize Posh for all of their HR needs, to be perfectly honest, but most specifically, any form that they need for their HR personnel files and also their employee handbooks. The employee handbooks are very precise, and we know it covers all legal obligations. And even more so, especially when you get into those state by state specifics, such as meal breaks and rest breaks and paid sick time and sick leave. And I think it's interesting because sometimes from a franchisor's perspective, our businesses are doing business as Always Best Care, but in some particular states, on the application process, you must have the name of the actual business. And so you can't just simply provide a template that has Always Best Care on it, because that's not the legal entity name. That's just their DBA. And so utilizing the Posh website to know those state specific guidelines, because there's just no possible way for us to keep up with, all 50 states, is very, very imperative. So, and it's those HR documents that are the ones that are most utilized, from especially our industry as far as lawsuits go. So we encourage all of our franchisees to utilize any HR document from the Posh website, as well as their employee handbooks.
Great. How about you, Nikki?
Yeah, no, absolutely. The employee handbooks are probably number one game changer for our franchisees, and the fact that they are state compliant, and the fact that they are available in Microsoft Word. That might sound like kind of a simple thing, but I can't tell you how many times people try to download a PDF of something, and then now you have to have some sort of creative Adobe to modify it. It's a pain. These are built in a way that there's highlighted portions that call out, hey, make sure you're updating this section here to meet your business requirements. There's comments in the comment sections of Word that say, hey, remember, if you're in LA County, this part has to stay. You can't delete this, right? So it's almost like I mean, no disrespect to anybody, but it's dummy proof, right? It's a matter of going through it, and you're working on something that has been curated and put out there by attorneys who specialize in this. I can't voice enough. I mean, there's financial savings there for the franchisee. There's the ability for the franchisor to say, this is what we've partnered with to provide to you. There's just so many great reasons to do this for your franchisees.
Yeah, one thing that is unique about Posh and Posse is it is designed for franchise systems. It is designed around joint employment. So there are lots of little Easter eggs built in by the attorneys who are litigators to protect the franchisee, like what Sheila's mentioning, that we ensure that they're using their legal entity name. That's a big deal, instead of just using the brand name. Once you've used the legal entity name, now you can define it within that document as the brand, because it's clear, right? And acknowledgments in the handbook, acknowledgement section, or even standalone acknowledgments that we put in orientation with employees, where the employee acknowledges that they work exclusively for that one business, and not, even though it's, they're part of a larger brand, that their sole employer is. That you don't know how helpful that is for me in litigation when I have one of those documents. And that was the whole idea around Posse and Posh, is let's create documents and resources that folks can use to keep them out of hot water. And if they are in trouble, we have the tools and the resources we need to defend them well, as opposed to working with something from an HR vendor or something else that kind of checks the box. Yeah, it's an application. Yeah, it's a handbook, but it doesn't have the things that we really need to describe what the practice is and what the law is, right? It's generally a punt, right? That, we have a meal break policy, as required by applicable law. Well, what is applicable law? Like, how does that help an employee or the employer understand what the rules are? So could you, either of you, tell me about an example of where Posh helped you avoid direct involvement in a sensitive employment related issue with one of your franchisees?
I have one, Sheila, but if you've got one top of mind, go for it.
Well, we recently had a franchisee who actually was served a lawsuit for wrongful termination, and it was through the from the HR materials that they gained through the Postinelli website, and it was in the state of Washington, which is a more highly regulated state. That once the franchisee reached out to Postinelli and gave them the case, it was easy to defend because everything was right there in line. So I think it is very, very important. It is built for, like Angelo said, franchisor and franchisee friendly. And I think that it's all the added protection and legal language that is already implied in the documents that helps the safety net of the franchisees. And although, just from a personal perspective, although we as the franchisor always want to stay protected, we also want our franchisees to be protected and not have to worry about those outside litigation claims and being sued and being served papers, because that's a scary thing. And, everybody panics when you're served legal papers, no matter what it is, because it's always going to be an expense, whether you settle, whether you go to court, or, even to have a consultation. So I think that that's where the benefit comes in, is having that peace of mind that these are built by attorneys. They have that extra legal language. They have a little bit more built-in protection, and to know that they're defensible once there is an action that needs to take place or might take place.
One question that came in that I would love for you all to talk on is how you get franchisees to utilize the resources. How do they actually make sure that they're adopting them without running afoul of joint employment? And the question was specifically, hey, we have an arbitration a program within our franchise agreement with the franchisee. So if we have a dispute with the franchisee, that's going to arbitration. But what do we do to get franchisees to get their employees on arbitration? How do we accomplish that? Nikki, you want to
Go
take
ahead,
that
Nikki.
one?
So one of the SME teams that I was talking about earlier that I have the pleasure of providing oversight to is our brand standards team. And our brand standards team is responsible for exactly what it sounds like, is ensuring that we have consistency across our brand. And that really comes down to, ensuring that we are putting information out to say, here's what you're required to do when it comes to being a franchisee in our brand. This is a requirement of you to stay with that. Now, of course, we always have to say, right, we don't want to direct from an employment terms and conditions perspective. So I'm not going to put standards that say you have to provide XYZ benefits to your employees, or you have to, pay a certain amount to your employees. But what I am going to do is I'm going to say, in order to help mitigate risk, you are required to implement an arbitration program for your employees at your business. And then I'm going to point them in that brand standard to, here's where to go to access the arbitration agreement, the FAQs that come along with that. But we also, that's how we're going to drive people. We use different kind of training tools here that are designed for them to a quick 5-minute video they can watch. They can watch us share a screen, how to access Posh, how to get in, how to search for the most commonly searched items, how to use it, how to download it once it gets into Word, how to update it. And we're constantly, oh, hey, yep, I know I've shared this 7 times in the last 2 months. Okay, here it is again. I'm going to send it to you. And eventually, because they don't need it until they need it. And then when they need it now. So that's when you got to get them. And you just got to keep reinforcing that message and use your brand standards to your advantage to do that.
Great. Sheila, anything to add there?
No, I would just, from the very early out of the box get-go, once a franchisee signs their franchise agreement and we begin that that training to that initial owner, that we're telling them right from the beginning that we are providing this service to them, and that, the Postinelli is our preferred platform for all HR. And as Nikki stated, we have that 5-minute video we show them. We show the ease and the access. And really, to be perfectly honest, Angelo, there's not a hard buy-in from the franchisees, because once you show them the platform and how easy it is to access the information, how easy it is to obtain the different forms, and how easy it is to navigate, and all this extra work is actually, they don't have to go out and get a W-4 from one place and get an I-9 from, the website, and get a different form from someplace else. Everything is right there. It's really a no-brainer as to why somebody would even go somewhere else to utilize it. So it's a very, very easy sell for us. And we use it as our compliance standard as well.
It's great, and we really try to do our part here too. I mean, our end game is to have legally compliant systems such that when there is a lawsuit or an issue, we can defend them well, right? It's really about the ultimate, legal services that come on the tail end, and having the right ingredients to defend against a DOL investigation or a lawsuit. So and I think, Sheila, what you mentioned, that is the ideal time, is when you have a new franchisee coming on before they've developed bad habits or gotten things from the wrong place, right? And we do our part to assist with those orientations. We send out client alerts every time a major law is updated or something is updated on Posh or Posse, right? It's not a static vehicle. Last question for you, and then we'll get to talking about, we did this a little out of order where we're talking about Posh and Posse before we really told anybody what it is, but I did that on purpose. So how do you use it as a brand differentiator for you versus your competitors?
I think Nikki really hit it on the nail when, it's really a way to differentiate your brand and have a standard across the brand. There's buy-in from everyone because it's such an easy platform to utilize. We know it's compliant. We know it will meet a compliance program, from state regulatory to federal regulatory. And just the ease of use. I mean, it's so easy to utilize and access. And I will, not to discredit you, Angelo, or anyone from the Postinelli law firm, but I know that we've even had franchisees who have utilized the platform who have gone to other outside attorneys when they have had an issue, and been very so complimentary of, well, you had everything in place, you were utilizing the right terminology, you were utilizing the right forms, and where did you get this information? So I just think it's such an easy tool to utilize. And the other thing that I will compliment Postinelli on is the information that comes from Postinelli on a monthly basis, or even more so via emails and updates. I mean, consistently, if there is something that is updated on the Posh platform, there's an email that goes out to everyone that's a subscriber that lets them know in a particular state or region that, this has been updated and the effective date it's going to go into place, and you need to change this, that, or the other. So I think it's not only the platform itself, but it's the ease of use and reminders of when changes need to be made. The information that Posh and Posse put forth to all of us, I think, is just wonderful.
Wonderful. All right. Well, thank you. Thank you very much, both of you. Let me just spend the last couple of minutes telling you what it is. So this is really a cost share platform. We have thousands of subscribers all around the country. And so when a court sees one of our arbitration agreements, or the DOL sees our off the clock work policy, they've seen it before, right? And we are able to get feedback in real time to update and strengthen all of our materials and agreements. These are the type of issues, as you look back on your screen, that we see change based on state laws that we are consistently updating. We have resources that are industry specific, state specific, all created by lawyers, very easy to use. We'll get you a full demo if you are interested. I'm going to run a poll here in a second, but I want to just show you a couple of the features. So you effectively click on your state, and this is all customizable. You can actually put franchise or specific resources on here that have been vetted and we can maintain for compliance. So for example, some businesses like to use their own template version of a handbook, but we still put our disclaimers on it and add it into the proprietary section. But this is an example of a guidance piece, right? So this is a employment guide. These exist for every state. You just click on one of the hyperlinks, like you see there's a hyperlink here for the handbook. And that will give you, that's not the only way to access the Florida handbook, but one way. And then that guide has all of the laws at a federal level, a state level, and city, if there are city ordinances, and then we'll link the document associated with that guidance if there is one. So wage theft notice, yeah, we'll be providing the wage theft notice. 51 handbooks. This is some example, right, that just to demonstrate that not everything is created equal, where you would have a handbook acknowledgement, right, where it's specific to an employee of a franchisee, understanding that they work solely and exclusively for that business. We've got time of hire checklist to help the franchisee go through at the time of hire all the employment applications, the offer letters, all the things that they need to make sure they have in the handbook. This is another example of the acknowledgement form I was referencing that we would want in orientation, right at the hire when you're doing your onboarding. There are arbitration agreements for every state that can be used in every state that have been tried, tested, and true. Enforced many times. When we use our arbitration agreement, we normally don't even have to file a motion to compel. We can just convince the other side that they're going to lose, and we should try to talk about settlement. Interview questions and lots of hiring resources. So, you know, a lot of information for you, and the actual agreements like meal waivers and things like that as well. So why don't we launch our poll now if we can. Sydney and Tara and Samantha are on this call. They are two of our folks that really run the POSH program. So if you'd like information about it and you'd like to set up a demo with us, we'd be happy to do that. You know, again, it's a wonderful resource. The Posse resource is pretty new. That's relatively new, so we're excited to get this out, you know, beyond just home care. And this has been a dream of mine for a long time, and we are here finally. And then the other thing that we do that I'll let you scan, and then I promise to let you go, is standing demos. If you don't want the pressure of a one-on-one demo, but you'd like to join a demo with others, we do standing demos both for, I know there's home care and other industries on, both for POSH and Posse. So let me get you that information. This is the QR code for POSH, and that stands, by the way, for Pulsanelli Online Solutions for Home Care. So that's the home care specific one. And then here is the QR code for Posse, which stands for Pulsanelli Online Solution Services for Everyone. That's what it is. Solution service for everyone. It's very, very hard with Posse. We were trying to come up with something catchy that would also have franchise in it. You can't get F in anything and make it sound right. So that's what we got. Posse, hopefully you'll remember it. Sydney, thank you for having us. I know we're out of time. Any questions I did not get to, I will follow up. I saw that there were some others that were just coming in right now.
Yeah, no, absolutely. Thank you, Angelo, Sheila, and Nikki Hollis, not Holes. Sorry about that earlier in the webinar. But no, thank you guys so much. This was super informative. There were a lot of questions that came in, so I'll make sure to field those to you guys post webinar. But for anyone who's still on, you will be receiving a copy of the recording and the slide deck from me this evening. But if you do have any questions, please feel free to email those to me once you receive my email, and I can definitely connect you with Angelo, Nikki, or Sheila. But thank you guys again, and thank you to Pulsanelli for sponsoring, and hope everyone has a great rest of your week, and hopefully I get to see some of you guys at the IFA Advocacy Summit next week.
Absolutely.
Thank
Wonderful.
you.
Thanks, everyone.
Our pleasure.